So now, moving to our segment 1, I'm going to briefly introduce our speakers and moderator for this first segment. So our moderator will be Mauricio Duarte, who is the COO and Justice Entrepreneur with A2J TEC and a counsel partner of Legal Plus. Thomas Delay Fortin is the head of legal and governance at the Badminton World Federation, and Lee V. Bien is a legal manager at ZTE Malaysia Corporation, and Patrick Klotz is the co-founder and CEO of Mindset and Swiss Tech Solutions. So without further ado, I will go ahead and pass the floor over to our speakers and our moderator today, Mauricio.
Thank you, Chelsea. And from my side of the world, good night to everyone. But to everyone else, I guess good day, good morning. It's a pleasure to be back with AIAC and to be speaking about something that I come across every single day. That is software development, developing contracts, especially in software development. Sometimes it's fun, sometimes it's not as fun. Sometimes I had a joke that sometimes we should create a black belt for software development contracts, because you can get so much learning and you're never an expert. It's like karate that you can try, but you're never going to be an expert. But besides that, I'm very happy to be moderating this panel with everyone else. Today, we're going to focus on how you can customize the software development contract that AIAC has about with the tech committee. And we're going to focus especially on the appendices of the contract. And just to give a brief overview before I give the word to my fellow panelists, usually if someone has worked on a software development contract before, or someone has seen, there are sometimes technical aspects, or let's say things that go beyond only a legal approach, but have more of a technical component. So for instance, deliverables of a project, what is going to be the programming language that you're going to use, what is the scope of work, and many other, let's say, topics and ideas that not necessarily come from the legal side. They come more from the tech industry. So for instance, the first time that I heard scope of work, it was like, what is that? What is a licensing agreement? Again, when I was baby stepping into the tech industry. But nowadays, if you want to customize a contract, many of those complex topics, instead of having infinite contract of 10,000 pages or 100 of pages, you can add or limit the number of appendices that are going to have different technical components. So probably today I want to start with one of the let's say, more complex topics around any type of software development contract. That, again, in the era of compliance that we are entering time and time again, we have seen on the news the recent scandals on data protection, especially we probably have heard about the recent incidents on Facebook. That's why the sudden change to now being called Meta instead of Facebook. Many felt it was just a way of avoiding the exposure that came with Facebook and some data protection. But besides the point, I think data protection and confidentiality are core principles to any software development contract nowadays. Probably a couple of years back, data protection was a trend. GDPR came, but now we see that not only GDPR purposes, but every single country is starting to have a trend on having their own data protection standards, which goes hand by hand on confidentiality on some of the contractual agreements. For instance, I have seen in the past that sometimes you tie up data protection measures that you should take with the confidential information that you can and you cannot share with your employees or with other vendors on that specific contract. So probably, Thomas, I know that you have had experience with data protection confidentiality before, but why would you say, let's say, the importance or the relevance of those type of provisions on a contract like this? Would you, let's say, describe, is it better to have it on appendix? Is it better to have it on the body of the contract? How the parties should decide, where should I add such a complex and sensitive topic within my contract. So Thomas, feel free to discuss what is, in your experience, the best approach, and any other thoughts.
Thank you, Mauricio. In general, I would say this depends on the type of data that is being transferred, if any, the type of data subjects that you have, and so on. In the context of here, we're talking about software development. So, well, to do a link with what we have in the SDC, we have Article 11 that includes some basic provisions on data protection. However, if you're if you're a customer in particular who would like to transfer sensitive personal data to your developer, you might be better served by making a dedicated data processing agreement that you could include as part of the appendices to your SDC. Now, if you do that, there's Article 3 in which you need to incorporate it. And what this allows you to be a lot more technical in the information you have in there. Article 11, once again, includes basic provisions about data protection. However, in this dedicated data protection agreement, data processing agreement, you may want to add the various types of data that you're sharing. You might want to add purpose of how this data can be used. You may want to add some safeguards around the storage of this data and so on. So it's always better, especially when data is sensitive, to have a more tailored approach. Templates do exist on the internet. You can create your own if that's an important need for you. So for these to get back to your actual question, I would probably advise for these more technical questions to have a dedicated appendix that you can, to which you can refer through your main contract. Thank you.
And on the other hand, Thomas, besides, let's say, data protection, that is one component. On the confidentiality side, for instance, what are some of the good practices on software development? For instance, I have seen on my own side, in my own practice, and again, this could be as customizable as you want and the level of compliance that you might have, that some provisions might ask if you are a developer of a software or an application or a solution, you have to make all your employees or colleagues working on that same solution to sign NDAs. Or you can limit the exposure of the data to just authorized, let's say, vendors or authorized third parties. How, let's say, can we balance in some aspects confidentiality with being able to be efficient in delivering a final solution? Because at least I can talk from my perspective. On the software side, sometimes I have to, let's say, negotiate those contracts, and is, okay, you want me to be very limited on who I can share my information with, but also you want me on a tight deadline to deliver a solution on the software side. So what are some good practices, how we can create a, let's say, good balance, and what are some other considerations on the confidentiality provisions and approaches for a software development contract?
Thank you once again. So perhaps in this context, I will talk from a user perspective or a customer perspective. Like for data privacy, it's probably important to have a tailored approach. And we tend to use, I understand here today we're talking about a standard form contract, but it's important to remember that these agreements can be tailored according to your needs. It doesn't mean that we have a specific NDA, such as the one we have in Appendix 10, or we have Article 11 on confidentiality, that we have to use them as they're drafted. So users, customers need to realize that not all of their data is that confidential, and they can try to strike a balance to be efficient on one side, but also to make sure that their data is protected. I speak from the perspective of a sports organization, and in our context, when we have software development needs, we would want to have an NDA or some form of confidentiality because we happen to share business information, we happen to share personal information about athletes and so on. So that would be the need for our confidentiality, which for us is very important. But some other organizations, they may want to develop a normal app that can be imagined through because of their regular business activities. And in that case, well, is it that important to have a very thorough confidentiality clause or NDA? Perhaps not. So there's something about striking a balance in here. Thank you.
Great, thank you, Thomas. And if anyone has additional questions on this specific topic we're gonna address them at the end. But now I want to go to another, let's say, what I call the heart of many disputes on the software contracts, and it's the root of many of my headaches late at night, like today, which is the scope of work of a software agreement. And let's say, when I came across with the term scope of work, again, as I mentioned, I was like, what is a scope of work? But once you start getting into the industry, you start understanding the implications of scope of work, deliverables, what are the specifications and requirements. It goes to a level of complexity that that's why you can never become a black belt or an expert on software development contracts. But Patrick, let's say with those, let's say, general considerations, what are some important provisions on the scope of work, again, on a software development contract? What are some additional good practices that the drafters that take into consideration the AIAC, let's say, standard contract should consider whenever they are, let's say, writing a provision about the scope of work, deliverables, and overall understanding the specific requirements for delivering a software solution?
Thank you very much, Maurizio. And I think I emphasize it again because it's important what Thomas just said before, right? It's a template, and I think it's even written in the disclaimer of the appendices. These are templates, and they should be really modified to fit the needs of the customer and the developer. So I'm from the developer side. We provide digital transformation solutions, which at a big part is software development too. And I think to easily answer your question, I think the communication, that is the most important part between the customer and the developer. Right now, that's easier said than done. And as you mentioned also, this is not about software is never about a standard product, right? It's not like you go to buy a car and you see the car already before you buy it. You know, it has 4 tires and it has 4 seats or 7 seats and things like that, right? So you are going to discuss something that does not exist yet. And of course, the imagination or the ideas that the customer has might not necessarily fit to what the developer understands. And that's why I'm saying the communication is so extremely important. I mean, what you put on the paper then should be the common understanding on how you see things. But it's a normal thing that you always have this kind of discrepancies in the understanding or in the expectation that the customer had. Again, then I'm coming back to the communication. I think it's so important that you have a regular communication with the customer, or the customer with the developer too, right? Even when you have this, let's say, different understandings or point of views, that you can easily adjust it and correct it. Ideally, during the project, depending on which methodology you're using for the software development. For example, with the Agile approach, it's far more easier, right, than with Waterfall, because you can adjust it during the next sprint. But then also you can use the other appendices, right, for like updates and changes when you come to agreement that this was not in the initial scope, and requirements have changed during the project also. Yeah, I think shortly explained that will be the most important.
And I think you mentioned something that I found very important, Patrick, and you basically, we are creating a contract of something that is unknown. How can we, let's say, add exact provisions or precise provisions on something that we don't know that it's going to exist in the future, or it's contingent upon many different variables? For instance, just to give a quick pragmatic case, I was recently working on a project with a no-code tool, which I'm not going to disclose. And that no-code tool that the client selected got purchased by another company, and they disclaim, we're, let's say, done with that product. We just acquired them, but we are not going to develop additional features. So what happens? Let's say, well, those are the type of things that could eventually, let's say, create additional issues. And my other, let's say, regarding the scoping and timelines, Patrick, I have another question is what are some good practices to try to be as precise, although it's impossible to be as precise on software development contracts, but are some good ideas or some good tips that, let's say, our audience or anyone using that tech form from the AIAC should consider on, let's say, trying to prevent many conflicts or problems with the scope of work as they draft this contract?
Yeah, I can just maybe explain how we do it, and I have a very good experience with that. I'm not sure if that is the best or the perfect way, but for us, so far, we didn't have any disputes. I mean, that became really legal disputes. Of course, again, you have always like different point of view. So what we do is we get involved very early in the scoping and the specification. So we do that together with the customer. It's not like the customer gives us like a 300 pages document with that is the specifications, please execute, right? We're not, that's why I also said like we're not like just a software development company that executes what is on the paper. So we start by running workshops together with the customer. We cover that on the consultancy part. So yes, it is paid, but we say the value of it is that you have like a clear specification and understanding from the developer's point of view, right? Because if you as a customer specify something, that doesn't mean the developer really understands that. So we are sitting together with the customer, and depending on the project size, that can be a 4-hour workshop. It can be a 2, 4, or 5 days workshop, mostly not longer than that. And as a result or an outcome of that workshop, you will have these kind of specifications and descriptions with the features, the functions, even the timeline or the idea. And with that document, then basically you can go to a software developer and have it developed. Ideally, of course, we are happy we can continue doing that, because that we have the advantage of then like having written that paper and understanding the project and the idea. But we don't do any kind of this lock-in, right? So we offer the consultancy part, writing that document, and then offering also, of course, the execution or the development parts. So that's our approach. And again, so far we were very well with this idea.
And before moving on to, let's say, the next big core issue of customizing a contract is, and this is probably one of the questions, Patrick, that you can have even more experiences. How can you communicate sometimes? Because many of your clients on a software development side sometimes are not as technical. So sometimes you have to communicate at a technical level. Let's imagine they want this software that does this, and that, but they don't necessarily know the programming language that you should use, the platform that you should use, what type of license, what are the type of permissions involved. So one of the biggest debates on the, say, legal technology in general in the tech industry is how you can communicate from a development standpoint the requirements of the client and vice versa, how the client can convey really well on a technical, let's say, side with the development team or with the developers what they want. In your experience, what is a good, let's say, tip on that so that we can avoid, let's say, misaligning expectations and generating, again, a different assurances on the scope of work and what are going to be the deliverables on a project?
Sure. Yeah, thanks, Maurice. It's a very good question, basically. Two things I would say. So first is the workshop. So we have a lead engineer or a technical engineer involved in that already. So the guy would know already, right? Like the mindset or the thinking or the ideas of the customer, which he then can or she can then bring back to the tech team, to the developers. And the second one is the methodology that we are using. I mentioned it before. We do Agile, specifically Scrum. And we're working with 2-week sprints. So you can imagine that we go with the big project, we break it down in smaller 2 weeks sub projects where you develop a small feature, a small item. For example, an item could be the login window for the user, right? And we develop that. And then end of the sprint, we have a meeting together with the customer. That is the tech team with the product owner, like the Scrum Master and the customer together, right? And the tech team would present and demo that to the customer. That means also no other interface, but the tech guys show what they have done directly to the customer, and the customer say, great job, I don't like this, I don't like that, right? And the PO, the product owner, would take that feedback back, right, into the next sprint, and we can update according to the requirements or changes that the customer really wanted. If the change is, of course, in that big scope, but the customer anytime has also the chance to add new features, new ideas, which go into the backlog and then get added, right? So I think with that methodology, you have like a really good communication and exchange with the customer. Yeah.
Great, thank you, Patrick. And I do see a question that probably relates to that specific topic. And Surinder, I hope I'm pronouncing your name right, mentions on a question is, should the scope of work refer back to the functional and specification requirement, which has the features and functions of the software agreed by both the developer and the customer? So do you think that's a good approach? Again, I have my own answer, but I would defer back to you, Patrick. Should the scope of work then refer back to the functional and specifications at very technical level?
Yeah, from my perspective, definitely. I mean, everything goes hand in hand in the end, right? And if you see Appendix 1, you have there also the sections for the functions, but also for the software specifications, which you can either add there or you can have it in a separate document. And ideally, right, you make sure that all the appendices, right, they work hand in hand together, right? Because later you have in Appendix 2, you have like the project schedule, where you have again the deliverables, right, and the deadlines and maybe the payment for it. But that works then also together with the requirements, right, and the sub project that I just mentioned. The same goes for the testing, right? In the end, you want to test those specifications or the requirement, right? So yeah, that is like goes through the contract, and the appendices like a green line, or how you say, a red line, right? That should all work together. Yeah, that's my perspective. I'm not sure if you share that, Maurizio.
Let's say it depends. And for instance, things that I do sometimes when I have to develop a contract is I do refer back to a more technical specifications, and sometimes we diagram. One of the things that we usually do is document every single, we call it, let's say, document every single workflow. Imagine how the process should look from a macro level to a micro level, let's say. And sometimes it's imagine you want to create a case management system, or you want to make improvements. There is an in and there's an out. There's an output that is going to be generated. But in that macro process, there's micro processes on every single functionality. So sometimes we try to diagram so the client has a visual representation, and then we also make that callback to the technical requirements and those specifications. So there are many approaches. I would say, again, and this is probably answers the question from Nassim, that I hope I'm pronouncing his name right as well. This is a standard contract template. So that means is a concerted effort from practitioners around the world, not only practitioners on the legal side and dispute resolution side, but also on the technology side, that came together and tried to give a uniform template, as hard as that sounds, for to be used and be customizable. For instance, we had practitioners from civil law systems to common law systems, and sometimes the legal terminology changes. So again, this contract can be used outside of Malaysia, can be used in the United States, can be used in Canada. For instance, I'm originally from a civil law system country in Guatemala, but now I live in the US. There is a common law, but I know that many of the stipulations and provisions on the agreement on the standard form can be used for my purposes. So again, This is a template contract that can be adjusted, customizable. You can change the appendices, you can add appendices, you can change the provisions. This is what I call the starting point that should always be, let's say, modified and adjusted to your needs. So thank you for that, Patrick. And again, to be on time, I want to go to the third component, not necessarily the least important. I would say it's just as important as all the other three, let's say, components that we have discussed. And whenever, let's imagine, we have the scope of work, we know the deliverables, we know the requirements, and we know the timelines for delivering a software development project. Now, how can we make sure, from a perspective of the user, that the project is acceptable? How should it be tested? What are the things that should be considered on that? So with that, I would like to I would probably like to ask you, let's say, some first general considerations on the testing and acceptance phase of a software development project, which again, probably it's going to be a determining factor if a contract ends in good terms, or we could be exploring any type of dispute resolution or any type of conflicts between the parties. Because let's imagine the scope of work that was initially intended didn't met the expectations. So what are some good considerations to have on the testing and acceptance phase? And also considering that the AIAC standard TEC contract provides certain, let's say, tips on testing and acceptance.
Okay, thank you, Mario. And good morning, everyone. So first of all, I think in general, the key to a successful contract without ending it on the need to actually having to resolve the dispute, it's really communication, which just now Patrick has already mentioned, especially when technology is something that it changes every day. So when it comes to, even though we have the scope of work and specification all listed down, but when it comes to the testing stage, it's still something that, because it's a new product, so we are not very sure whether this product will actually pass the test. So of course, that's why we have divided into two phases, which is the inspection phase, whereby the developer themselves will conduct the test and to make sure that the software that they are going to deliver actually fulfills their acceptance test, and then thereafter only we present it to the customer and get them to test. So when it comes to the acceptance test process, it's usually the engineers from the developer side and the customer side, they will just sit down together and just come out with a agreed form of what sort of test that they will conduct to test whether the software has passed. So in this way, we will know what the customer is expecting. So that's why when you know what is our end goal, and from there we can counter whatever obstacles that may have. Yeah, so in the event that, because in practice we know that, okay, we know A, B, C, D is what this software has to pass, but in reality, most of the time, it may not be 100% passing rate. So that's why the rectification process is also rather important, as it gives the developer a chance to actually rectify the product and to know from the customer point of view that what more they are expecting that may not be recorded down, and from there we can innovate and try to fulfill the customer needs.
And let's say now entering on some of the testing that you mentioned, which I think it's critical for both sides, not only for the developer of the software, but also, let's say, the end client. It could be a business or it could be a single user that is requesting that software development. On your perspective, Lee, who should be doing the testing then? Should it be the developer? Should it be the client? Should it be both? What is a good, let's say, approach on doing testing for, let's say, satisfaction of both parties and to limit liability on both sides? What are some good tips, practices, or even provisions that probably you have seen on the acceptance and testing side?
Okay, usually we will, in practice, what we usually do is the developer side will actually conduct all the testing, but in the presence of the customer, so at least they know what are we doing, and then thereafter we'll prepare a report for them to review. So then we will get it from there, because sometimes the customer, they may not have the technical knowledge to actually test the software because they are not the one who developed it. So usually this is the more of a mutual benefit way. So at least we know we are following what is supposed to be done. If we let the customer to test it themselves, they may not test it in the right way, and thereafter they decided not to accept the software, and then you will end up in a not very favorable condition to both parties.
Okay, and let's say further add the complexity on the acceptance and testing phase, what are some common, and probably in your experience and practice, what are some common issues that can be prevented from a contractual let's say, point of view, that sometimes you have seen that they were not prevented? So when we are in the acceptance and testing phase, it could give, let's say, a path to, let's say, potential conflicts or potential misunderstanding between the parties. Are there additional things that could be added on the standard document that has been created on the software development that we should think of, or we should consider, or that you have seen, or it's a good practice to consider as well?
I would say it really depends on what the product is that we are developing today. So if it's a very generic and it's something that common and everybody would know how to use it, then of course the more specific it will be, the better, so that you don't open room for dispute. Because in the event the contract is vague, then we know that it's subject to different parties' interpretation. However, if today we are talking about a new technology that no one has done it before, and there are a lot of uncertainties, then we would advise them to actually leave some room to buffer. You don't be too strict about it, so that parties can negotiate, and also to add in more buffer time, because more often than not, when it's a new technology and when a bug happens, it's not something that the tech team can resolve it immediately. They will need some time to actually check it out, what is happening and whatnot. And if in this sort of event, the contract has stipulated a very strict timeline that, for example, within 3 days or sometimes even 48 hours, that the developer has to rectify it. Otherwise, it will be deemed as a default. Then it will put the developer and the tech team in a very difficult position. So sometimes what we would actually suggest is, if the customer insists to have a solution, we will give them a temporary solution within a specific period of time. However, we will need to come out with a permanent solution to rectify the bug within a longer period of time, so that at least we can make sure that there's no delay on the products, and also we can also give them a permanent solution, so that will end up in a win-win situation. Yeah.
Thank you, Lee. And for purposes of time, I know we have 6 minutes, but one other question, Lee, before, let's say, opening, if there are additional questions. I do see that there is one more that I want to address. What is a usual, let's say, metric or a standard time frame for the testing phase? Is there a specific amount, or again, as you have mentioned, it's going to depend on the complexity of the project? Should it be 1 month? Should it be 6 months? Should it be 1 week? What is a usual, let's say, common practice on the tech industry on the testing phase, how long it should take, or what is a reasonable amount of time that it should be provided for the testing phase?
Okay, I would think that usually it's around 1 to 2 months. This should be a reasonable time frame, but of course it also depends on the software itself and also the number of products that we are actually selling to the customer today. So for example, if today we have 1 million units, so of course the testing, it cannot be conducted within this short 1 to 2 months frame, and it usually will be conducted in phases, like phase 1, how many products, phase 2, how many products, and usually it's like this.
Okay, great. Thank you, Lee.
Thank you.
So I don't know if there's additional questions from the audience, but I do have, again, I've seen some Q&As on the specific terms on the contract. And again, as a final consideration, as we have mentioned, both Thomas, Patrick, and Lee, myself, and even Chelsea, it is always important to let's say, consider that as a template contract, as any template that you can find. Let's say you can find purchase agreement of fish on Google to a more complex. For instance, the last time I was just looking at it on cryptocurrency mining contracts, I didn't find any, but again, that shows that there are some templates that are still not necessarily on the internet. But as any template, it should always be customizable. And by customizable, it's not only putting names and changing periods, it should do, let's say, really take into consideration the project at hand, the stakeholders in the project, the specifications, what type of project are we developing? For instance, it's not necessarily the same to develop a website, to develop a custom software for a case management system within a law firm. And again, every project has its complexities, and that is gonna dictate, again, the project is gonna dictate timelines, it's gonna dictate data protection, it's gonna dictate the scope of work. So it always take, let's say, the contract, I think it's a good baseline to start any type of project. But again, always the customizable part is always important. And that's why I think it's important also on the disclaimer on the contract, is that always it's advisable to get legal assistance in order to make the adjustments correctly. And here comes probably my final consideration, as I don't think there are additional questions, and which is something that I have shared. Let's say my practice is more on the legal tech side, but there has been always this discussion on, are attorneys gonna lose their jobs because now everything can be automated and you can find templates on the internet and everything can be based on templates. And I, let's say, push back to that notion in the sense that attorneys, regardless of the era, regardless of the development of technology, are always going to be important because they can provide substantive insights on what are good provisions to add on a specific contract. Now that also comes with a competitive advantage on certain attorneys that are going to be more familiar with some technical aspects or technical definitions on a project. They're going to understand better certain aspects of the technology industry. So again, we cannot necessarily part from the premise that everything can be automated. I still think there's a lot of value of adjusting, customizing contracts to specific needs. There are certain areas in which you can use standard documents for everything. But again, I think this contract is a very good effort to try to unify many practices on the tech industry on different parts of the world. Again, probably the tech ecosystem on the United States is not necessarily the same as it was in my home country in Guatemala, which is a very small country, and probably the standards on my home country are not necessarily the same in Malaysia, in Japan, and any other country in the world. So this is, again, it's a compilation of different efforts, of different insights, different backgrounds, different legal systems. And with that, I think there's a lot of value and efforts. So this reminds me when I was studying, let's say, the uniform instruments on international law for arbitration, when I was a practitioner back in the day, when we read the model law, the New York Convention. Again, there's a lot of values because it got insight from different stakeholders around the world, and it has created international instruments as successful, for instance, as the New York Convention. But with that, I think we are right on time. So with that, I want to thank again Patrick, Thomas, and Lee for your time today, for your morning, my evening. And with that, I leave the floor to the second panel. So Chelsea, thank you for everything.
Thank you so much to our speakers of segment 1. It was a pleasure having you here. And for our attendees, these are members of our TEC expert committee. So we're going to have just a quick short break, and we'll go ahead and get our speakers for segment 2 up and ready to go. And then we'll go ahead and start with segment 2.